American Bar Association's Family Law Litigation Committee's roundtable today. My name is Shazia Sparkman. A little bit about me. I am the founder and managing partner of Sparkman Law in Tampa, member of the American Bar Association, and also the Florida Bar's Family Law section. Briefly, I began my career as a prosecutor myself, and thereafter have been primarily focused in complex family law cases. And since 2014, have devoted the bulk of my practice to cases involving severe parental alienation, which is the topic that we're here today. I'm honored to be with the esteemed panel that I will be briefly introducing you to. One of the goals of today's discussion is really to help shed light on this very important issue and concept of parental alienation that is often misapplied, misunderstood, and altogether often missed by the courts. So our hope by today's discussion in going through the various issues surrounding identifying cases of parental alienation in the courts is to shed some more transparent information as to the importance of swift court intervention to protect the children involved in these situations. In a quote that I'd recently come across several times in different literature involving parental alienation, and I think really is aptly applied to this, is actually by Alec Baldwin, in which he says, to be pulled into the American family law system in most states is like being tied to the back of a pickup truck and dragged down a gravel road late at night. No one can hear your cries and complaints, and it is not over until they say it's over. I think that very accurately describes much of what the litigants and victims feel in these types of cases. With that, I would like to introduce our panel, starting with attorney Ashish Joshi. He is the owner and founder of the firm Joshi Attorneys and Counselors. Mr. Joshi's work focuses exclusively on family law matters, including severe parental alienation, pathological child enmeshment, child abuse, and international child kidnapping. He has counseled and represented clients in state and federal courts across the United States and internationally, including in India, United Kingdom, Canada, and more. Mr. Joshi has been admitted to the bar of the Supreme Court of the United States, state bars of New York, Michigan, District of Columbia, and Gujarat, India. He has published numerous articles and co-authored books on parental alienation and child abuse. In fact, one of his most recent books that he has authored, entitled Litigating Parental Alienation and Evaluating, evaluating and presenting an effective case in court, published by the American Bar Association. I am going to hopefully bring up my screen so I can share with you. I hope everyone can see this. If I need to zoom in or zoom out, please feel free to use the chat function, and I will do my best to do that. This is the book that Mr. Joshi just recently authored. It is in tune to the discussion that we're going to have today. I've included the link at the bottom of that slide to purchase the book. Important to note that both ABA members and non-ABA members, American Bar Association members, can go on and purchase this book in both e-book form or hard copy form. The next panelist, the Honorable Darlene O'Brien. Judge O'Brien was first appointed to the, I hope I'm going to say this right, Washtenaw County Probate Judge in 2006. She is a graduate of the Notre Dame Law School and earned her bachelor's degree from the University of Toledo. Following her federal clerkship, Judge O'Brien was previously an active trial attorney, for 24 years, representing clients in criminal and civil matters, including those heard in family court. She's been admitted to practice in the U.S. District Court Michigan, as well as a U.S. Sixth Circuit Court of Appeals. We're really pleased to have her today on this panel. And last but not least, Judge Christina Carley, Ontario County Court Judge. Judge Carley graduated from the University of Buffalo Law School, actually my alma mater as well, in 1997. Judge Carley served as a prosecutor at the Erie County District Attorney's Office for 3 years, and then at Monroe County District Attorney's Office for 10 years. She worked in the Domestic Violence Child Abuse Unit at the Monroe County District Attorney's Office, where she was promoted to Deputy Bureau Chief and then the Bureau Chief. In 2011, Judge Carley went into private practice, focusing on family, matrimonial law, and criminal law. As a private attorney, she's represented hundreds of litigants in family court, including complex child custody cases and cases involving issues of parental alienation. In 2018, she ran for Ontario County Court Judge, and she is seated as the first female Ontario County Court Judge. She presides over many contentious custody cases involving various degrees of parental alienation. Thank you to all three of the panelists for being here today to discuss this important issue. I just wanted to make a note that throughout the discussion, if there are any questions that come up that the audience members ask, please do use the chat feature. I will be actively monitoring those questions, and we will reserve the latter half of this discussion so that we can address as many of those questions that you all may have for us. So with that, we will begin. And I'd like to start with Mr. Joshi, if we could ask you, can you define what is parental alienation?
Thank you, Shazia. Thank you for the kind introduction. It's been a pleasure to work with you all and be here today on this panel. So let's define the term parental alienation. There are different definitions of this term when we take a look at the judicial decisions from around the country and internationally. But there's a consensus amongst the professional community that the term parental alienation refers to the mental condition in which a child aligns herself or himself with one parent, typically who are engaged in a high conflict or contentious divorce or separation proceeding, and rejects the relationship with the other parent without legitimate justification. And those are the key words, without legitimate justification. It's important to distinguish parental alienation, which is the phenomenon or refers to the child's relationship with the rejected parent, and alienating behaviors, which are behaviors manifested by the alienating parent or the favored parent. And it's not necessary that where there is evidence of alienating behaviors, we do have a case of parental alienation. Not always. You may have a case of parental alienation if there are alienating behaviors. You may not have a case of parental alienation despite the alienating behaviors. So that's a term how it's normally defined. But it's also important to say what parental alienation is not. It's not an assumption. In other words, simply because a child is rejecting a parent or resisting the relationship with the parent does not allow anyone to assume that it's a case of parental alienation. You need to dig deeper than that. And that's many a time that's a strawman argument put forward in courts as to why this theory is not valid or doesn't have scientific underpinning, simply because it assumes the rejection is because of alienation. And that's not true.
And I assume, if I can jump in, I assume that what you mean by that when you dig deeper is as a case particularly is evolving in the court system, digging deeper where you might have one or two, as you said, indicators. What else do you need to do so that when you're identifying it to the courts, that dig deeper, what does that look like? If you could talk about that.
Well, you need to investigate the case. If you happen to be the attorney for the targeted parent, you need to present the evidence as to why it's parental alienation. You bear the burden of proof. If you happen to be the guardian ad litem who is appointed by the judge or the court to investigate the case, it's your duty to figure out what is the reason behind the child's rejection of the parent or resistance to the contact with the parent. Is it because of other parents' manipulation, coaching, undue influence, alienating behaviors? Is it because of the rejected parent's own abusive behavior and neglect? Is it a combination of both? Are there other factors at play, like normal child-adolescent development or other family factors resulting into one parent having a bad or a dysfunctional relationship? But at the end of the day, you have to have evidence of alienating behaviors by the favored parent, and you have to have evidence of signs of alienation in the child. You have to look at other things, of course, but these are the two main things that you look at before you call it the case, before you call a case of parental alienation.
How, in your experience, Mr. Joshi, trying these cases, have the courts sort of evolved in their in how they view the concept of parental alienation when it's presented by us attorneys? Has anything shifted, and from what to what, if it has?
There was a wonderful study done, Shazia, that was published in 2020 in a book called Parental Alienation, Science and Law. In fact, I have the book here, and we want to show the cover to people. Parental Alienation, Science and Law, published by Charles C. Thomas Publishers, editors Demosthenes Lorandos and William Burnett. And in this book, several authors have contributed chapters, including well-known experts such as Dr. Richard Warshak, Dr. Amy Baker, Dr. Jennifer Harmon, of course, Drs. Burnett and Lorandos as well. And Dr. Lorandos wrote about a research project that he did with his colleagues that surveyed the cases from family courts around the country from 1985 to 2018. And they looked at cases where parental alienation was alleged, parental alienation was found by the court, either after an evidentiary hearing, a trial, custody evaluation, stipulation, or otherwise, what sort of interventions were put in place, and whether an expert was allowed to opine on the phenomenon of parental alienation. And it leaves no doubt whatsoever that overwhelming courts in America, family courts, have acknowledged the concept of parental alienation. Some have different terms for the phenomenon. Some call it pathogenic parenting. Some call it gatekeeping. Sometimes courts use the term child affected by parental relationship distress, CAPRD, which is out of DSM-5. But overall, the courts have accepted the term, and they have acknowledged it, and they have taken intervention depending on how the case is. It's a spectrum, as we know. It could be a mild case, a moderate case, or a severe case. But the trend that we have seen, Shazia, in the past decade or so, is the trial courts moving away from the debate of whether parental alienation syndrome is real or not, whether syndrome exists in DSM-5 or is covered under DSM-5 or not, and rather focusing their attention on the alienating behaviors and how harmful they have been to the child's mental and emotional well-being and to the child's relationship with the other parent. We see less and less cases which go into the debates of the esoteric syndrome or theory, and more cases that outline and focus on the negative, toxic behaviors and how they affect the children.
So when you spoke about the varying degrees, I mean, that's part of the proof factor, as you also kind of discussed proving it. How do you prove? I mean, and I know that that's a question that has to be unpacked. But how does a litigator, how does an attorney prove a case of parental alienation? And if you could touch on the degrees a little bit in that response as well.
Sure. There are several ways you can present a case of alienation in a court of law. I like to use the five-factor model that has been put forward by Dr. Amy Baker and her colleagues. And the five-factor model essentially looks at five factors in combination. The first factor you look at is to see whether the child is rejecting the parent or resisting the relationship with the parent. And it's important to note that you don't need a child to refuse seeing the parent completely. In other words, you may have a case where a child is seeing the parent, going on parenting time, going on visitation, but there is absolutely no engagement. The child doesn't engage with the rejected parent. The child doesn't come for dinners. The child is just locked up in the bedroom, put the headphones or earbuds on, and there's absolutely no relationship.
Let me jump in there. Do you find that it's difficult when you're trying a case and explaining to a court that that while there is, let's say, time sharing and visitation on a regular basis, that engagement, lack of engagement, is one of the indicators, and can still be a case of severe parental alienation?
Absolutely. Absolutely. As I always argue that it's an issue of quantity and quality. You look at the quantity of parenting time. If we have court-ordered visitation parenting time orders, we look at how many parenting time visitations have been abided by. Are there violations of court orders? But you also look at the quality of parenting time, because frequently children, especially older teenagers, know that their favorite parent is going to be in trouble if they refuse to go and see the rejected parent. And the alienating parent will be able to make the children go on visitation, but there is absolutely no engagement. There is no relationship. At times, the children act as like spies, allies of the rejected favorite parent. They go and snoop around in computers. They try to create trouble. They call the CPS, protective services. They call the police. And they try to make it appear as if the rejected parent is simply incompetent to parent the child. So you look at the dynamic from an overarching viewpoint. That's factor one. Factor two is you look at the baseline relationship. What has been the relationship of the rejected parent with the child from a historical perspective? Was that parent an involved parent? Was that parent an absentee parent? Before the separation or divorce or breakdown, was that parent involved in the child's life? You look at parent-teacher school conferences, extracurricular activities, family vacations, presence at medical appointments, presence in all other domestic family events. And if we see a well-engaged parent who was part of the child's life, but all of a sudden that parent is being now rejected as being absent or incompetent or abusive, that's a red flag as well. Factor three is absence of severe abuse or neglect on the part of the rejected parent. And here it becomes a little tricky because you have to look at evidence, not simply allegations. You look at if there are findings made by the protective services of substantiation of abuse. You look at if there are any court findings. Sometimes you have convictions of abuse, sometimes you have guilty pleas. Sometimes the abuse is independently documented, but it has to be simply more than allegations of the favorite parent or the child. Factor four, you look at the alienating behaviors. And this is where Dr. Baker has, as many people know, has written about the 17 alienating strategies. And these behaviors are supported by empirically done research. We have research papers, we have scientific studies done that support this 17 behaviors theory. It's not just speculation. And it's cross-cultural and cross-geographic. So you look at if there's evidence of some of those 17. You don't need all 17. You could have 4 or 5 or 6 or 10, but you still need evidence of some 17 alienating behaviors. And last but not the least, the proof is in the pudding. You look at the signs of alienation present in the child. There are 8 well-known symptoms of alienated children, and the alienated child or children should demonstrate some of those 8 alienating symptoms. That's how we typically present the case of alienation in the court of law.
I'm going to jump to, and thank you for that overview, Ashish. Judge O'Brien, in sort of picking up off of what Ashish just went through as far as proving it in court, as a trial judge, how do you, in particular, make the finding in a case of parental alienation?
Well, good afternoon, everyone, and thank you, Shazia, for your kind introduction. In terms of the finding of parental alienation, I try not to get tied up in the terminology because you can get mired in the semantics. It's not outcome determinative for me, whether it's a syndrome, whether it's in the DSM. What I'm interested in is the behavior and the effects of the behavior. Is the alienating parent telegraphing to the child that it would be somehow dangerous to be with the other parent? In Michigan, where I've been sitting as a trial court judge for the last 15 years, we look to the best interest factors, and we have 12 of them, and one of them that I tell parents is very important to me is the willingness and ability of a parent to facilitate and encourage a close and continuing relationship between the child and the other parent. So it's each parent's responsibility to foster that. And if, as Ashish has said, you have all the other, the indicators that are necessary, there's an absence of severe abuse and neglect. I am not as concerned about the terminology as the evidence. And in terms of the evidence, what's so important for the attorneys to remember is that we need to have a record. The motions that the attorney files in the case over whatever period of time are not evidence. We need things admitted at the evidentiary hearing. Sometimes I've had attorneys say, "Judge, you've been sitting on the bench for so long, you understand this," and they expect you to do something, but you need the evidence. And for me, the gold standard really is to have a comprehensive psychological evaluation of the parties and the child, with expert testimony from a psychologist who's schooled in child development, attachment, resilience, abuse, parental alienation, and family dynamics. Now that's labor intensive and it's expensive, and not all parties can afford that. Some courts can provide funding for it, but without that, the attorneys need to make a record of what has the conduct been, what has the parent been doing that is alienating. Is parenting time being denied? Are there missed visits? Is there bad mouthing of the targeted parent in front of the child? Are others allowed to badmouth the targeted parent in front of the child? And parental alienation is so often fueled by anger, and that anger often leaks out into text messages between the parties and really caustic social media postings. So that type of evidence needs to be documented and presented and admitted as evidence, so I can make that best interest finding that those behaviors are harmful to the child and make my determinations regarding custody and parenting time.
Thank you for that. Ashish, back to you for a minute. What are, if you can tell us, the top three fallacies that often compromise parental alienation cases and or the outcomes that a court might find or in making the finding, like Judge O'Brien just stated?
Well, there are several fallacies that are commonly found in litigating these cases, and perhaps the best resource that I can give to people who are attending this program is an article written by Dr. Richard Warshak, in 2015 in the publication called Professional Psychology, Research and Practice. And this is a peer-reviewed article in a scientific journal, professional journal, and it's titled 10 Parental Alienation Fallacies That Compromise Decisions in Court and in Therapy. And I have found this article to be very helpful, and I have often used it in litigation to help the court understand some of the commonly held misconceptions, fallacies, and what I call a propaganda of disinformation. Deliberate falsehoods that are just thrown out to confuse the court and obfuscate the real issues. If we are to narrow down to three fallacies, I would say the first one is an assumption that the child's rejection of a parent is normal in high conflict or contentious divorce cases and is short term as well. And it will just die off on its own when things go somewhat back to normal. In other words, it's very common to see guardians ad litem or minors counsel or therapists or court-appointed professionals tell the rejected parent that just show patience, show empathy, don't go to court to enforce your parenting time, and things will get resolved on their own. And that typically does not happen if you do indeed have a case of alienation. One of the worst things that a lawyer can do if you are representing a rejected parent is to tell that parent to agree to a cooling off period or a no contact period and not have the kids come and see them. That usually entrenches alienation and encourages and enables more distorted thinking on part of the children. So that's one. Second, the assumption that the children will be quote unquote traumatized if they are removed from the alienating parent and put with the targeted parent. And this appears to be counterintuitive, but that's precisely what needs to happen in cases of alienation. The children need to spend more time with the parent that they reject. They need more experience of that parent and with that parent to counter the toxic propaganda of alienation from the other side. The third fallacy is that the courts really can't do anything about older teenagers. That if you have a 15-year-old or 16-year-old, you can't really make them follow court orders. You can't really do anything about it, and their wishes should dominate the custody and parenting time decisions. And that's a fallacy as well, because we have seen in cases after cases that when the courts come down with decisions, and when the children, even older children, are specifically told about the court decision, they do abide by that. We don't allow our 16, 17-year-old to go out and drink in the bars. We have rules for when they can drive a vehicle. We have rules when they can attend a school. And by the same token, these children should not be allowed to drive the bus when it comes to parenting and custody decisions. So these are some of the commonly held fallacies that you come across in cases of alienation. We can discuss more later if we have time.
Thank you. Judge Carley, kind of tagging along on a court's ability or a court's power, let's say, what can you discuss with us as far as some of the dangers that could be present when a court may inadvertently, let's say, side with an alienator and thereby sort of indirectly almost enable the alienation to continue throughout the course of litigation?
First of all, good afternoon, everyone. It's an absolute pleasure serving today. I became a family court judge because I care so much about families and children, and I have the history of being a domestic violence child abuse prosecutor. I then became a defense attorney and a family court lawyer. And my obvious fear as being a judge is getting it wrong. And there are situations, of course, where children are being physically, sexually, and emotionally abused. And so when you're presented with this evidence, you want to make sure that you're hearing that this is possible, that the children are, of course, being abused. But we also have to recognize as judges that parental alienation exists and is a form of child abuse, and we have to handle it with the same way that we would handle these other more accepted, I guess I would say, forms of child abuse. I never want to get it wrong. So it's very important as a judge to have an open mind and don't jump to conclusions, but understand that parental alienation exists. It happens on a variety of, a different scale. And I never want to make a decision to not allow the child to see the parent and create a gap, and the child can't see the parent. Because what I see daily in my court, we don't have guardian ad litems, we have attorney for the children, and they have to report the child's preference. So I hear on a daily basis, the child doesn't want to see that parent. And everyone, I should say everyone, but it's expected that the court is always going to follow the direction of the attorney for the child. The child doesn't want to see the parent, the child's not going to see the parent. And so in a case of parental alienation, the worst thing that I feel that I can do is reward the behavior of the alienating parent and prevent the child from seeing the targeted parent. So how do we do that? What can we do to make sure that we make a decision that's sound? And because once that gap happens and once access is suspended, then it becomes the status quo. And I hear from attorneys for the children all the time, well, the child doesn't want anything to change, the child does not want to see that parent, and that is my fear, is creating that rift, rewarding the targeted, or rewarding the alienated parent, and preventing this child from seeing two parents, to seeing a parent that loves them, wants to be with them. And so I try very hard from the beginning to ensure that if I have an order and one parent exercises self-help and denies the other parent access, immediately that's rectified and that there's make-up time, because I don't want to reward the parent who is alienating the other parent. And it's difficult. And just as Judge O'Brien said, we have to be guided by evidence. And attorneys must be prepared. If I leave practicing attorneys with any advice today, it is that you have to be prepared with respect to parental alienation. You have to understand what it is. You have to understand how to prove it. You have to be prepared in terms of the case law, in terms of how experts can play a critical role in the case. You've got to deliver the evidence to the judge so that we can, as I said, get it right.
Thank you, Judge Carly. Speaking of those professionals, attorney ad litems and guardian ad litems, Judge O'Brien, jumping back to you, because in talking about building a record, you spoke about psychological evaluations, and often these cases also accompany appointments of guardian ad litems or attorney ad litems, as Judge Carly stated. What can you talk about as far as what the benefits of those types of professionals can be in cases of parental alienation, as well as some of the pitfalls that we can come across?
Well, quite frankly, I don't see any benefit in having a lawyer guardian ad litem. I can, as part of my determination, interview the child discreetly in camera without the attorneys present, not on the bench. I always do it in the presence of someone else, of course, and we make a record of it. But that's one of our best interest factors. What is the preference of the child? So the child can tell me directly. I don't see any benefit in having a lawyer guardian ad litem, because the adults need to make the decisions, and the child needs, to the extent possible, to not get embroiled in the parents' disputes. And giving them a lawyer guardian ad litem is like giving them a megaphone, and it's just, I don't see the benefit, so I don't do that. But I do sometimes appoint a guardian ad litem. And that person can be a lawyer, of course, but they're not acting as a lawyer guardian ad litem. They're not the lawyer for the child. They are appointed by the court to tell the court what is in the best interest of the child. And even still, if this person is not the right person, because they don't understand the issues of, power dynamics, or that the child can be so compromised by the alienating parent that they no longer can exercise free will and judgment, the attorney or the guardian ad litem who is appointed needs to understand and look behind that shroud, because the child may be saying words that aren't based on reason or reality. So I've had the benefit of having some excellent attorneys in my court who are appointed as guardian ad litem to tell me what's in the best interest of the child, and if they have a social work background, if they're well-versed in all of these necessary concepts, a good guardian ad litem could help the court. But as I said, I don't see the benefit of a lawyer guardian ad litem, and it must be hard for Judge Carley to have to listen every time there's a hearing to that, because it may not be peeling the layers of the onion back to see if that's really a true and free and reasoned choice.
I liked your analogy to the megaphone, Judge O'Brien. In your opinion, do you believe that, or do you see that early interventions by the courts in cases where there are indicators of parental alienation can perhaps nip that problem right in the bud and end it?
I like to think so, and I like to think that there are things that I do to help foster that. I like setting the tone from the very beginning by, like I said, telling the parents that a really important factor for me is how they foster the relationship between the child and the other parent. That is so important to me. And our court actually has a class. We call it, our county does, the SMILE program, Start Making It Livable for Everyone. And it's a 2-hour free class that focuses on what's in the best interest of the child, and it focuses on how important it is that each parent fosters the relationship between the parent and the other child, unless, of course, it would be injurious to the child for some reason. That's something that always has to be kept in mind. And the way I enforce that is I don't even allow oral argument on post-judgment motions pertaining to the child unless and until the party attends that free 2-hour class. And they're doing it virtually now, so there really is no excuse not to listen to that. So if they get that early enough on, before a lot of bitterness and anger gets involved, hopefully that helps. And I try to keep a level playing field. If a party doesn't have an attorney and they're going to agree, let's say, to sole legal custody, that puts the advantage for the parent that has custody in terms of potentially alienating the child physically, geographically, because they've got a lot more leeway in moving the child. So I want to make sure that a party understands the consequences of that type of decision. And if there is a whiff of alienation, then I want to make it clear to the parties that I can change custody if I think that it's in the best interest of the child, and because I think that fostering the relationship with the other parent is so important, that that's something that they have to be careful of, a change of custody or parenting time. I do think that our court system is not well suited for family court matters because it creates winners and losers. There's bitterness, people get embroiled in these proceedings, and sometimes they totally expend what would have been the child's college education fund to pay for the attorneys and for the psychological evaluations and that type of thing. So right from the very beginning, all of my cases are required to go to mediation unless there's a reason not to, such as prior abuse between the parties. And mediation is good as an alternative dispute resolution technique, but I don't really see that it effectively deals with the hurt and the anger and the bitterness from a failed relationship. So I'm really very fortunate in our trial court because we have what is called a peacemaking court. And I have to credit Judge Timothy Connors for creating this court and getting it sanctioned by our state court administrative office because it is a healing court. It focuses on all the baggage that these people are carrying from all the hurts and injustices they think that the other person has done over the years. And what is involved is people have to agree to go, and the parties sit in circle with a trained peacemaker, and there's a talking stick or piece that gets passed around, and you don't talk unless you're holding that. So, yeah, it requires people to listen, and so often people stop listening. So it can be a truly transformative process. You can do a circle with just the parents. You can bring in, when you have another significant other or a new wife or husband, they can be brought into this circle. And it absolutely can transform the relationship. So that's something that I highly encourage. But I know not all courts have that, but they might want to look into it. Orders that are specific and require no bad-mouthing of the other party, no toxic social media, not to demean the other party in that way. And as Judge Carley said, if parenting time orders aren't being honored, then I do a swift referral to our friend of court for parenting time enforcement. And when the parent sees that additional makeup parenting time could be granted to the other party, sometimes that helps. So those are just some of the things I try to do early on and throughout the process that I hope helps.
Thank you so much, Judge O'Brien. And speaking of, the hurt that often accompanies, these types of extremely contentious and often long-running child custody cases, particularly those involving parental alienation. Judge Carley, a lot of times us attorneys face the difficulty of presenting a parental alienation case and receiving the pushback of the traditional, well, it's justified estrangement. It's not parental alienation because of X, Y, or Z allegation, typically a domestic violence allegation, something of that nature. How should trial judges address allegations that are made? So Ashish had earlier distinguished between the importance of not just looking at the allegations, but sort of digging really deep to make sure that there's substantiations to those allegations. So when there's not, what do you do as a trial judge? What can you tell us about that?
Well, what I found it happens quite frequently is the attorney for the child in my jurisdiction, which with their giving the child the megaphone, I love that. It puts judges sometimes in a real untenable position because it's reported this child does not want to see dad because dad is physically abusive, and that becomes the over and over. And then you, as a trial judge and a judge that was a domestic violence child abuse prosecutor, of course I fear not hearing the voice of the child, not intervening and protecting the child. But what I have found, when there's just this broad allegation without substantiation, that's when I have to dig, what's really going on here? Because it's easy to talk to a child and say, okay, you should be really scared of going over there because dad is very dangerous, and mom's really nervous about you being there, and make sure you keep your phone on you and all of these things. So then the child reports to either the court or the attorney, and then it seems horrible. But when you dig, well, what is happening? And you ask the child to articulate. And oftentimes they can't because it's not really happening, and they don't have the ability to give a time, a place, and specifics that can be substantiated or corroborated by evidence. So it is a very difficult position to be in, but I am glad that I am here because I have the experience from both sides. I have represented children who were terribly physically and sexually abused. But I've also represented parents who were the targeted parent and suffered years of not being able to spend time with their child, tuck them into bed at night, go to their soccer game, and it has deprived the child from knowing that parent. And that can have the same devastating effects on a child as physical abuse and sexual abuse. And we see the same reactions in children or effects: anxiety, depression, suicide, alcohol abuse, eating disorders. The effect of parental alienation on children has the same, it's the same as if they're being physically abused. So what do I do as a judge? Well, first of all, I stay up to date, and it's trainings like this that are so important. Reading a book that Ashish wrote and understanding the complexities and how counterintuitive parental alienation is. I mean, we teach jurors in the criminal jury instructions that you look at the demeanor of someone. Well, oftentimes it's flopped or flip-flopped in a parental alienation case. The alienating parent is often calm, cool, just presents well in court, and then you have the targeted parent who's a wreck, justifiably, because they are being denied access to their child, and so they're often angry and upset. And so I've really had to catch myself and be like, why is this guy coming? I don't like this attitude. But then I think about, if I didn't see my son Henry for a month, I'd be way worse. And so I always have to remind myself, wait a minute. Don't be fooled by the exterior. We have to dig deeper. And I don't allow myself to rush to judgment on these cases. And I have to critically analyze the causation. Is the rejection of this parent, is it justified by what the allegation is from the alienating parent, and in my court, what the child is telling their lawyer? So again, it is education. It's staying open-minded. It's understanding the dynamics and how difficult it is to just make decisions how someone's acting in court. And I see it all the time. Judges are like, well, this guy came in and he's being disrespectful to me. And next thing you know, visitations are suspended. It is our job to critically analyze and understand the dynamics of parental alienation. And I agree with what Judge it in the bud. I've become a little, this is my third year on the bench. I'm a relatively new judge, and I love hearing the advice that Judge O'Brien gave. But I've started to be very clear when I get a hint of the possibility of parental alienation. I make it very clear on the record day one. Okay, there's an order, it has to be followed. If you don't, you are in jeopardy of possibly losing time, losing custody. If I find, and I say it to both sides, mom, dad, whomever, if I find that you are saying negative things about the other parent, if you're tearing down the other parent, if you're allowing other people to tear down the parent, if you are not nurturing a relationship or fostering a relationship with the other parent, you risk losing custody. And so right away when the self-help starts, no. And I found that it really works and doesn't create that status quo that I was speaking of.
And in that critical analysis that you're doing, and Judge O'Brien, you please feel free to jump in as well, essentially when you're trying to avoid any risk of a false positive, right, when you're considering a case of parental alienation. So, I mean, is that essentially, you know, the process that you're going through to ensure when you see those first hints and enforcing those orders, even sometimes do you find that it's form over substance even? So orders and the form might be being followed, but the substance, and I think Ashish had pointed out, the quality, let's say, and so there's intangible things that need to be proven. Are those some of the things that you look at as well in terms of avoiding the risks that are associated with false positives?
I'm sorry, is it a question to me or to Judge Carly? I'm not sure.
The two judges, I'm sorry.
Judge O'Brien, you could start.
Well, there's always a risk of false positives, and that's something that haunts us all of the time. So it's really important just to try and follow the evidence, I think, as much as you can, and make sure that you have the evidence there to base your decision on.
It is difficult, but we took this job to be a judge and took an oath. And I stand firmly committed to families and doing the hard work. And sometimes, you know, it's spending a significant amount of time with a case, scheduling it for a very prompt hearing so that we can have testimony, see evidence, see if what the child is saying is, if it fits with just rejecting a parent. I think what Ashish said, I hear, look, I was a great mom. I was involved. I went to everything. And as soon as the separation, then all of a sudden that person's no longer appropriate to care for the child. They're dangerous. So that's what I really focus on, just that stark contrast. So I ask, sir, you let mom watch the child when you were together. Why now? Why all of a sudden is she so dangerous? But when you were off playing golf, you know, for 18 holes all day, she was great to be watching the child. So you have to be educated in the dynamics. And I saw that there was just a question that came up of how do you do that as a judge? It's very difficult, but it is gauging a situation based on the experience and a commitment to justice. And that's why I participate in these events, not only to, you know, bestow my education on everyone else, but I learn every time I'm part of one of these seminars. I learn from experts, and I think as judges, we can't walk around like we know everything, because we don't. We have to be open. I mean, I gotta say, when Judge O'Brien was talking about the circle with the stick, I've got a lot of people that probably wouldn't use the stick in the right way, and I'm like, wow, I don't know if that would, but being open to, wow, that may seem different and maybe something that's not done, but being open to new ways to bridge this gap, because if we don't get to them right from the beginning, we have a similar program, it's not SMILE, it's called FIT. If you get to them quickly in the beginning and you let them know But if you can tell a parent, say, look, you understand the negative impact it would have if you hit your son over the head with a baseball bat. Yes, of course. Do you understand that if you deprive access to a loving parent, it has the same effect? Maybe not physically, but emotionally. No, but teaching parents they can hurt their child in this fashion is so important. So we have to be open to something new, like what Judge O'Brien said, and say, oh, that would never work. We have to be open.
And some of that involves, getting in early with the mental health interventions that often are necessary in these cases. Ashish, can you touch on some of those interventions that are effective? What measures related to mental health evaluations or interventions help or work?
Sure, I'll be happy to do that. But can I just quickly go back to one thing that we talked about regarding guardians ad litem?
For sure. Yeah.
So in my experience of litigating these cases in different courts around the country, jurisdictions use different labels. New York, for example, calls them attorney for children. Colorado calls them child legal representative. Illinois has, minors counsel. Michigan has two categories, guardian ad litem and lawyer guardian ad litem. And Massachusetts actually has two categories of guardians ad litem, one based on mental health expertise and another legal expertise, a lawyer. And I absolutely agree with Judge O'Brien that in most cases involving alienation or alienating behaviors, it would be a huge mistake to appoint an attorney for the child. Because the child indeed gets a megaphone, and then in effect, the alienating parent has two attorneys or two advocates in the courtroom, his or her own, and the child's attorney who simply acts as the mouthpiece of what child wants. And that is not to say that the voice of the child cannot be heard. Judges do interview children if they are of sufficient age to obtain their reasonable preference in terms of custody and parenting time. And the key word here is reasonable. And we have many decisions from around the corners of the country which have said that in alienation cases, children's preferences were unreasonable and was a product of distorted thinking. And that's why the courts did not give them adequate weight or any weight. As to intervention, well, it depends. If it's a mild case of alienation, and the favored parent is open and willing to engage in counseling to learn about the dynamic, then traditional psychotherapy may help. Traditional tools of psychoeducation may help as well. It all depends upon the cooperation from the favored parent and the willingness to change and modify their behavior. On the other hand, if we have a case of moderate to severe alienation, we need specialized intervention programs. Some of those programs are such as family bridges or turning points for families, which are specifically geared towards remedying alienation. And once those programs take place and the child continues to be with an aftercare professional in the local community, and in these situations, it is important to think about a temporary no contact period between the child and the favored parent. No amount of therapy or counseling or intervention is going to work in a moderate to severe case of alienation if the child goes back into the same toxic, poisonous environment. That poison has to stop dripping. And that's why we need this no contact orders in some cases to allow the child to break through the loyalty bind, develop resilience, clarify their distorted thinking, confront their irrational fears about the targeted parent, and then we see if the alienating parent has gone for counseling, has tried to understand what just happened here, and is willing to change and modify his or her behaviors. And one thing we didn't discuss but comes up all the time is this gender issue. And I'm sure Judge Carley and Judge O'Brien have heard this as well. It's often put forward that parental alienation is some cockamamie theory dreamt up by men to protect against their own abusive behavior. And only women are harmed by this theory. It's not a gender issue. Both men and women have found to engage in alienation. No gender has monopoly on this particular kind of abuse.
Thank you for actually touching on that, Ashish, and you're right. On the mental health interventions, how important is it, Ashish, if you could talk on this briefly too, for those providers that might be engaged in the case or even appointed on a case, be familiar with parental alienation and identifying the varying degrees of alienation?
Oh, absolutely. You need an expert. You need, in fact, a specialist when you are looking at alienation intervention. If you don't have someone who understands the alienation dynamic and is trained to handle the situations, there is a significant risk that that particular professional is going to buy into irrational fears, distorted thinking that the child and the alienating parent demonstrate. If the child's irrational fears and the irrational belief system continues to be validated without being gently confronted in a therapeutic setting, without being explored further, without being subjected to critical thinking, then it's never going to work. Number one issue in this case is education. This is why these cases get so crazy, so expensive. You know, we have cases involving parents behaving horribly. We have cases of child homicide. We have cases of parents committing suicide in some cases. Why? Because these cases languish in courts for years and years and years. And that's typically because we have guardians ad litem or lawyers or evaluators who don't go through training, who are not trained to understand how to deal with these cases. That's not to say they're operating out of malice or bad faith. They want to do a good job, they want to help the situation, but they are acting from their intuition. It could be professional intuition or clinical intuition. But it's simply, for example, how can I possibly encourage more parenting time when the child even refuses to get on the phone with this parent? That would not go well. So let's have a cooling off period and let's not make the child see the targeted parent. And then months go by and the resistance grows. It doesn't lessen. And we have motions after motions filed by lawyers. They walk into the courtroom, they meet in the hallway, they agree on some kind of a deal. The judge is simply given a stipulation to sign off on. And the next thing the judge knows is this big motion asking for custody change, sanctions, contempt. And the judge wonders what happened in the past 9 months. Yeah, you know?
Yes, it can be problematic. And one of the questions that came in a while ago actually touches, you sort of answered it squarely, a question on what resolutions could be offered to minimize the length of time, the expense, the emotional, the taxing that these families go through. A lot of it is what you just touched on, making sure that all of the individuals from the lawyers to the professionals are trained to the courts. And it starts with the education. So thank you for that, and I 100% agree. Going back to the judges, as we're kind of nearing the end of this discussion, what can you tell us lawyers or suggest to us representing targeted parents in these situations so that we could timely and swiftly propose effective interventions that you as judges would accept and feel could help in those cases?
Well, I'll jump in. I think it's important that attorneys come with a plan and not just say, well, we're leaving it up to you, Judge, to figure it out. Of course, a good psychological evaluation by an expert with knowledge and experience who does a thorough investigation and interviews and a home study, they can make recommendations that sets a path going forward. So that could be invaluable. Without that, sometimes you just need to, if you're satisfied that this is a case of alienation and that there isn't a danger if the child goes with the other parent, then you need to have that evidentiary hearing sooner rather than later and make your decision. It may involve changing custody, changing parenting time. The attorneys can ask for a review. They can ask, and they don't sometimes even need to ask. I'll just order it that the parties be in individual counseling themselves. If I'm going to be changing custody orders, that's hard for a parent who has had more custody, and they need some help going through the changes for their own sake. Some parents really they've become emotional cripples almost in terms of not being able to stand on their own 2 feet without having the child. They actually use the child as a crutch in social contexts and such, and to be able to build their own self-esteem and ego so that they don't need to have this enmeshment with the child in order to continue on. And as Ashish was saying, you know, the good psychoeducational counseling about the long-term consequences and effects, how these are really adverse childhood experiences that can affect the child physically going forward. I was really taken by a longitudinal study that I think it was Judith Wallerstein had done, and the finding that in high conflict cases, the children that go through that, 50% of them don't want to get married, and 2/3 of them actually don't ever want to have children themselves. I mean, if a parent realizes that what you're doing may mean that you never become a grandparent, you know, they really have to understand these long-term consequences. And we need more education and understanding in the profession, on the bench, and specific interventions, like Ashish had mentioned. Judge Carley?
Thank you. I would say to practicing lawyers who are handling these cases that creating a history or a chronology with supporting evidence and data is the first place to start. Act like a prosecutor or an investigator and collect data. Spend time with your client and learn everything about the family dynamic before and after separation. Collect pictures, video, medical records, school records, attendance records, any kind of communication between the parents and the child. I always say to people lie all the time, evidence doesn't. You have to collect and create this history because you have to educate a judge and you have to be bold. And you have to stand up when a judge is starting to make fun of you because they've never heard of such a thing. And, oh my gosh, it's very simple. The child doesn't want to see their parent because they're being abused. No, it's not. And then you're prepared and you have to stand and fight because a targeted parent is an abused parent and the child is being abused if there is, in fact, parental alienation. And so it is your responsibility to educate the court and be willing to do so. When they say, oh, that's, voodoo science or whatever. No, it's not. And here are the articles, here are these documents, here's the case law, it's accepted in our community. This is an example. Be prepared to dig your heels in and fight. And you have to do that by being prepared and knowing this case inside and out. Be creative. But I think the cases for me with parental alienation that were most difficult were dealing with parents who didn't have financial resources, because the impact of losing your child, whether you're a millionaire or minimum wage, is still the same, and it is a fundamental right to parent your child. And so I've been doing this a long time, and I would call up people and experts that I respected, and I would say, I got this case and I'm wondering if you take it on pro bono. And they would, over and over again. People want to help abused children and people who are suffering abuse like this. And so it's hard when you're doing your bills and you're charging for all this preparation. But, in a case like this might be a case that you take pro bono to help a child know and be with their parent that loves them so desperately. But it's education, it's preparation, and it's putting in the hard work. These are not cases that you can walk into court and shoot from the hip from. You have to have the evidence to present to the court, and you've got to fight. And so that would be my advice. Be creative, be educated, educate the judge, be prepared, and collect your evidence.
I love that. Thank you, Judge Carly. That's really, really great advice. And it's also just a great reinforcement for those of us like Ashish and I who do this every day. So thank you for that. I've seen lots of questions and comments come in. So thank you to everybody who's been participating. We will try to get to some of the questions before we close. I just want to give each of our panelists an opportunity to talk about, sort of what's on the horizon for parental alienation, litigation as a whole, as a concept in defense of parental alienation, in hopes of protecting the children, as I started off during the introduction saying that, that was one of our hopes and goals of this program. Ashish, I'll start with you as far as the road ahead.
Well, the road ahead, Shazia, there's little doubt that alienation exists. In fact, in my mind, there's no doubt at all. And if we take a look at the judicial decisions from around the country, the courts have made it clear as well. So that's a good thing. We are getting away from the noise and the smoke screen created by some detractors about the scientific validity of this phenomenon of parental alienation. That being said, we also find evidence of the theory being increasingly used in situations where it may not be appropriate. Not all bad behavior of a parent makes a case of parental alienation. Not all children who reject a parent or resist contact with the parent are alienated children. There are many factors to think about and many factors to evaluate before you allege alienation. And from my perspective, as someone who represents targeted parents in courtrooms and litigates these cases in different jurisdictions, your credibility is the key. If you lose your credibility before a court, that's the end of the story. So when you make an allegation of parental alienation, you are essentially alleging that the other parent, the alienating parent, is engaged in child emotional or psychological abuse. And you need to make that allegation pretty seriously. You need to think very seriously and do your homework before you make that allegation. So I would caution many lawyers to think twice before just filing a motion alleging alienation. By all means, cite the problems, talk about the concerns, invite the court to be a part of the resolution. Peacemaking courts where they're available are absolutely a good resource to consider. And if you are able to find a good professional who can help mediate some issues, great. But where it is a case of alienation, and you do have evidence of that, the sooner you get to a trial, the sooner you convince a court to give you an evidentiary hearing, better will it be for the children to get the intervention.
Thank you. Really quickly, there's just a thought that's been popping through my mind on the presentation for us attorneys in making the allegation of parental alienation, as you just said, and if carefully considering, before that allegation is made in a motion. What about maybe some of the ethical considerations that would go alongside making an argument for or against parental alienation in different cases as an attorney?
Well, that's a sticky wicket. as people like cricket say.
That's a legal term, sticky wicket.
Yeah, and I like it. I like it. I mean, can you say I believe in parental alienation and here it is, and then advocate against it and say, hey, it's junk science?
Well, it's my personal opinion that it is unethical for an attorney to endorse the theory of parental alienation, argue in favor of parental alienation, get the court to rely on that argument, give you the relief that your client needs in the particular case, only to flip your position when representing a parent accused of being an alienator. In other words, a lawyer who goes to court and argues in favor of the theory of alienation, put forward the research, articles, case law, and everything, should not be allowed to argue the exact opposite in a different case. We are not saying that a lawyer cannot challenge the findings or allegations of alienation or alienating behaviors. You can absolutely argue that this is not a case of alienation, and here's why. But to say that alienation theory is pseudoscience or junk science or doesn't exist, or that syndrome is not validated by any scientific evidence and whatnot, is simply beyond the pale at this point in time. And I think it's in violation of the rules of professional conduct, because as an attorney and officer of court, you have to show candor towards the tribunal and to the court. And in one case, you are putting forward the peer-reviewed research and all the research supporting the theory. In another case, you are promoting false propaganda and a theory of disinformation to mislead the court. So I think it would be unethical. I don't know what the judges think about it.
Judges, do you want to weigh in? Do you have any opinions on how, from the court's standpoint?
I agree that you can't say that this exists in one case as a concept and say it doesn't exist in another case, because as Ashish says, you lose your credibility. You're not saying that it doesn't apply in this case, but just to totally say this is not valid as a concept. I think that's really being disingenuous and unethical. Judge Carley?
I would agree. I was taught very early on by my mentor that as an attorney, your word is your bond. And at the end of the day, all we have is our own credibility and our reputation. And someone who's willing to flip-flop like that, I think it's unethical, and I think it shows what people will do for the almighty dollar, and that's somebody who really doesn't care about families and children. I have told everyone, or lawyers that appear in front of me, I am never going to be upset with you for fighting, for coming prepared and presenting and advocating very strenuously. I don't get upset with people for doing that. Come on, that's what I did. That's what I expect you to do, is to come in here and show me why you believe it exists and why it doesn't. That's not what I'm talking about. But to say in one instance that there is parental alienation and another that it's junk science, I think that's unethical. And we were talking a little bit earlier about what attorneys can do when being presented. I mean, I remember what it was like. You do your consult, someone comes in, they present great, you think they're a great parent, you take on their case, and then things happen. And so what do you do when you realize that your client is the problem? And I'm sure we have all been there. I had a case that sticks out in my mind, and I was talking to the mother who I represented on the phone, and she is bashing the dad. And then I hear the kid. And I was like, I won't say his name, but I was like, is that D, his name started with? Oh yeah, but he's in the back seat. He can't hear anything. He's not paying attention. And I told her, I said, I fired her. I said, I won't be part of this. I won't be part of you saying these negative things in front of the child. Well, they may be true. You'd say them to me. You cannot do this to your kid. And it happened time and time again. parents would bring their child in. And like, you can't have your kid here, but like, they just engage in this behavior oftentimes, and we see what we see, and we have to say, I can't represent you anymore because I won't engage in activity that could prevent a parent from seeing their child. And it's hard at times. We're all trying to make a living and do the right thing, but we have to stand up when presented in these situations. I believe, if we knew our client was purposefully molesting a child or continuing to engage in physical abuse, would we be able to represent that person in family court or in divorce? You got to look at yourself. Are you able to represent yourself represent this person who's doing this to a child? And we can also, as attorneys, encourage our clients to do the right thing. I've been fired for that too. But then at the end of the day, we can put our head on the pillow and sleep at night, knowing that we encouraged the parent to do the right thing. They didn't want any part of it, so you're not my client.
Excellent. Thank you, Judge Carly. That's a great ending note. Ashish, Judge O'Brien, Judge Carly, thank you so much. This was very helpful, and as we talked about, just a great continued education for those of us who are in this field. Thank you very much. We have a few minutes left, and I would like to get to just maybe a couple of the questions. Ashish, if you wanted to kind of take over on that note. Thank you for all the comments, everyone, by the way. And then one more time, I just wanted to plug again Ashish Joshi's book. I have the link up again. If you guys would like to go on and buy, you don't have to be a member of the American Bar Association. So thank you.
Thank you, Shazia. I just have a couple of questions here that I would like to discuss with the judges. One question that came in is, what do you do when the favored parent or the alienating parent wants the child to testify? They often want the child to come and testify against a rejected parent. And I have my own thoughts on that, but I'd like to judges to say, what do you think about that? You have a litigant that comes to you and say, I want the 10-year-old or 14-year-old take the stand in the trial and testify about whatever they want to say. How do you deal with that issue?
You want to go first?
Sure. So, like I said, New York is a bit different in terms of, every child has an attorney appointed to represent them. And I know there's an argument that that's good, that's bad, but that's just the way it is. I have found that when a parent threatens to call a child, the child's attorney goes nuts. And that's another legal term, like sticky wicket, Ashish. But they say no way and use it as, it shows that they really don't care about this child if they're willing to put them through this. We oftentimes do an in-camera of the child, or what we call a Lincoln hearing if there's alleged abuse. And so that is normally the route that we would take if the child, if we're going to take testimony from the child. And the way that we do that in my jurisdiction is in chambers with the stenographer, but the child's attorney is always present. I feel that I'm trained in interviewing children. I've received forensic interviewing training, so I feel comfortable because I know that when I'm questioning them, they're non-leading, non-suggestive questions. And, I find I get to the bottom of things oftentimes better than the attorneys for the children because they're just advocating for preference. And so in my time on the bench, it has never happened that the child is called. There's threats, but it generally never comes to fruition.
I have not had children testify in my court as well. Sometimes parents do come in and they're saying, listen to the child, I'll, put the child on the stand. You put the child on the stand, they're subject to cross-examination. Children need to be protected, not go through proceedings, adversarial proceedings. Their voice can be heard in different ways, through the guardian ad litem, through that in-camera interview with the judge. And sometimes their voice is heard in their medical records that become evidence. because they tell their doctors or their counselors their thoughts. So I don't have them taking a stand in my court. I've never said you cannot, but the attorneys know how I feel about it and how strongly I feel about it, and it just hasn't happened.
I have, on a slightly different topic, but somewhat related as well. In my experience, I have found that judges who are aggressive on enforcing their own orders, who make it clear that bad actions or violations will have consequences, either contempt citations or some sanctions or award of fees, usually don't end up having really nasty, drawn-on, crazy cases of alienation. They are able to manage the situation preemptively and in a much better way compared to some courts where you have a litany of violation of court orders or parenting time, but no consequences. Any thoughts on that?
Well, I'll jump in on that one. Courts aren't powerless, and we do have our contempt powers, and I found that sometimes just arraigning a parent on a show cause for contempt and advising them of all the penalties that they could be subject to a fine for each single contemptuous act. They could have to bear the costs of the proceedings and any of the expenses. They could be charged with the other party's attorney's fees and incarceration until they purge themselves of the contempt. That gets their attention sometimes.
That's Carly?
I would agree with that. I think prompt attention to violations of my court order really goes a long way to resolve the matter quicker. I know how infuriating it was when I represented targeted parents, and we have these, proof and substantial allegations, and then it's, well, we'll calendar this for 9 months down the road. And during that time, in that 9 months, the child doesn't see the parent. And then the alienated parent has unfettered access to remind the child how horrible the other parent is and how dangerous it is there and what's going to happen if you go there again. What's mom going to do? You could be hurt, or vice versa, dad telling against mom. So I have found, and it works, if there's a violation, we deal with it quickly, effectively. There's makeup time, and it's very well known I will not tolerate it. And I am stern, and I hopefully scare both sides that they are at risk of losing custody by engaging in this type of behavior. If it's, obviously, there are parents who are seeking to protect their child based on real things, but there's still an order. It has to be followed, and when it's not, quick, effective dealing with that. And they realize right out of the gate, I'm not going to play with her. This isn't going to go well for me. And so I found that it works. And it was so frustrating for me as an attorney to have to sit with parents who, you go to court, I know they had such anxiety about, we're getting to, all right, it's finally the day. Something's going to happen today that I'm going to see my child. And then nothing happens. And you go and nothing happens. And I've had cases where years went by. And luckily, in most of the cases that I've handled as a practicing attorney, it resolved itself eventually. And that's when there are the victories of soul and spirit, when you are a practicing attorney. But nothing can give back that lost time. And I think it's important as attorneys, I would often, when I was burning the midnight oil or whatever they say, away from my kid, think, I want someone would fight for me and my kid, and it's worth it. The most rewarding cases I have ever handled are where the targeted parent gets their kid back and they can resume that relationship. If I can give any advice, it is worth the time that you spend being prepared, fighting for your client, to eventually have them back with their child. And think to yourself, how would this feel if this was my kid? And so when I'm in court and I'm behind schedule and I'm frustrated and come on, we got to move these cases, I think, what if this was my son and I wasn't able to see him? And that's how we have to handle these cases, and really hear the evidence and stay on top of the literature and the data and the research and the cases and fight.
Thank you. Thank you, judges. We are right on time here. Thank you for taking the time. I think this was very helpful to the participants. We have got great comments and questions. And thank you to the American Bar Association and Section of Litigation for hosting this program. It's time that we take a stand together against this abuse. Parental alienation is child psychological abuse, and we need to end it. Thank you, everyone.
Thank you.